after being denied EFF appeals to have CR17 records revealed. The EFF has asked for permission to appeal Acting Judge Kasim Sardiwala's ruling that it, EFF, lacked the legal power to pursue the unsealing of President Cyril Ramaphosa's CR17 bank statements. In 2019, Deputy Judge President Audrey Ladwaba of the Gauteng High Court in Pretoria sealed the records after President Cyril Ramaphosa's lawyers asked that they not be made public because they contained confidential donor information. Sardiwala's decision now contradicts no fewer than 3 constitutional courts and/or of Supreme Court of Appeal judgments on the open justice concept, according to the EFF. They intend to appeal it to the Court of Appeal. The EFF has no grounds to contest the court's decision to seal President Cyril Ramaphosa's CR17 campaign bank statements, since it is not in the public interest, according to the North Gauteng High Court in Pretoria. On Thursday, when Ramaphosa spoke for the second time in the state capture inquiry, the EFF filed a plea to have his CR17 campaign bank account details opened. Lawyers for the party contended in papers filed in the Gauteng High Court in Pretoria that Sardiwala was mistaken in finding it had failed to prove it had any right to access those records. The statistics had been constantly exploited by Ramaphosa's critics, with no real proof to back them up, to infer that he was involved in the same corruption that he had promised to drive out. The EFF, according to Sardiwala, has not advanced any public or private interest that will be provided by public disclosure against the personal danger in which parties to the CR17 campaign affected and their actions will be put. The lawyers for the EFF claimed that the verdict was wrong. The sealed records are fundamental for our democracy, specifically related to the right to vote. Ledwaba encouraged the parties in the case, which ultimately included the EFF, to seek for the records to be released in an open court hearing. Ramaphosa was disputing the findings of Public Protector Busisiwe Ngwabane's report on his CR17 campaign, in which she indicated that he had not only lied to Parliament, but that his campaign was also perhaps involved in money laundering. Ramaphosa will also be required to reveal his contributors to Parliament, according to her. Ramaphosa was not constitutionally compelled to publish the identity of his CR17 backers, according to the majority of the Constitutional Court. The court also found no evidence to support Ngwabane's conclusion that Ramaphosa had exposed himself to a risk of conflict of interest between public responsibilities and private interests, or that he had used his position to profit himself, as the EFF had claimed. It further held that neither Ngwabane nor the EFF had shown any proof that Ramaphosa had personally benefited from the CR17 campaign, implying that he was not required to disclose those donations as benefits under the Executive Ethics Code. It is a leap in logic to hold that the president personally benefited from the donations made to the CR17 campaign, Justice Chris Jafta wrote. The ruling went on further. During Ngwabane's CR17 investigation, the EFF lobbied for the publication of the CR17 bank statements, which were contained in a classified Financial Intelligence Center report obtained by Ngwabane. Introducing a new precedent. It claimed Ramaphosa and his campaign managers had failed to present any evidence to support the decision to keep the data confidential. It goes on to say that if Ramaphosa wanted the record sealed, he should have paid for a substantive application. The Sardiwala judgment contradicts no fewer than 3 constitutional courts and Supreme Court of Appeal judgments on the open justice principle, the EFF argued. The EFF was also hoping to have a costs order given by Sardiwala in the case overturned because it was unjust, according to the EFF.